उधर सुप्रीम कोर्ट से सोमवार को भाजपा को बड़ी राहत मिली है। सुप्रीम कोर्ट ने जम्मू कश्मीर से अनुच्छेद 370 हटाने के फैसले को बरकरार रखा है। सीजेआई डीवाई चंद्रचूड़ ने कहा कि जम्मू कश्मीर भारत का अभिन्न अंग है, इसकी कोई आंतरिक संप्रभुता नहीं है। 5 अगस्त 2019 को मोदी सरकार ने जम्मू कश्मीर से अनुच्छेद 370 के प्रभाव को खत्म कर दिया था। साथ ही राज्य को 2 हिस्सों में जम्मू कश्मीर और लद्दाख में बांट दिया था और दोनों को केंद्र शासित प्रदेश बना दिया था। केंद्र के इस फैसले के खिलाफ सुप्रीम कोर्ट में 23 अर्जियां दी गई थी। सभी को सुनने के बाद सितंबर में कोर्ट ने फैसला सुरक्षित रख लिया था। 370 हटने के 4 साल 4 महीने 6 दिन बाद आज सुप्रीम कोर्ट में 5 जजों जस्टिस डीवाई चंद्रचूड़, जस्टिस संजय किशन कौल, जस्टिस संजीव खन्ना, जस्टिस बीआर गवई और जस्टिस सूर्यकांत की बेंच ने फैसला सुनाया।
If the power which is otherwise unavailable to the authority or body is exercised, or if the power that is available is improperly exercised, since the concurrence of the state government was not required for the exercise of power under Article 370(1)(d) to apply all provisions of the Constitution to the state, the President securing the concurrence of the Union of India on behalf of the state government is not mala fide. The next issue is the challenge to CO 272 on the ground that it is ultra vires Article 370(1)(d) because it modifies Article 370. We have held that the modification by CO 272 to Article 367 as it applies to Jammu and Kashmir had the effect of amending Article 370 and is thus ultra vires Article 370(1)(d). We have reached this conclusion for the following reasons. First, recourse must be had to the procedure contemplated by Article 370 Clause 3 if Article 370 is to cease to operate or is to be amended or modified in its application to the state of Jammu and Kashmir. No other procedure may be utilized to amend Article 370. Second, the rule of interpretation that a power under a statute must be exercised in accordance with the provisions of that statute and in no other manner is undoubtedly applicable to the Constitution. Third, from precedent, including Shankari Prasad Singh, Sajjan Singh, Kyoto Holohan, and Rajendra Shah, it emerges that the following aspects are of significance when assessing whether a change has been made to a provision of the Constitution. 1. A change may be either in terms of or in its effect. 2. A change can be said to have been made even if the language of the concerned provision is not directly amended by adding, subtracting, or modifying the language. This is a change in effect. And 3. If the effect of an amendment is to change a provision, such effect must be significant or appreciable. And 4. The substance of a change is more important than its form. Second, an assessment of whether a constitutional order amounts to a modification and consequently whether the procedure under Article 370 Clause 1 or under Article 370 Clause 3 ought to have been followed depends on this standard. Third, the effect of a provision of law is as important as its form. While the change sought to be made by paragraph 2 of CO 272 may appear to be a modification or amendment of Article 367 at first blush, its effect is to amend Article 370 itself. CO 272 changes the language to the proviso to Article 370 Clause 3 in 2 ways. First, it changes the language to the proviso to Article 370 Clause 3 in 2 ways. First, it changes the recommending body from the Constitution